Welcome to Lesson 4, Criminal Defenses Part 2. In the last lesson, we looked at some justification defenses. Remember that in asserting a justification defense, the actor admits that he or she committed a criminal act, but that he or she should not be convicted of a crime because he or she did the right thing under the circumstances, and that the law recognizes that particular defense. In this lesson, we will look at something different. We will look at excuse defenses. A defendant who asserts an excuse defense admits that the act he or she performed was not good, but that he or she should be relieved of criminal responsibility because of something about them or something about the situation, which the law recognizes in statute as a defense. In this lesson, we will be discussing the excuse defenses of insanity, infancy, intoxication, ignorance of the law, mistake, and entrapment. The insanity defense. The insanity defense is controversial and rarely used. It's controversial because it allows possibly dangerous people to be set free or to go to less secure mental hospitals where they might be released after a short period of time. There's also criticism of the insanity defense because there is no agreement among experts about what constitutes insanity and how to diagnose it. It's not like a clear-cut illness like having pneumonia or an injury like a broken bone. There's no test. There's no blood test for insanity. You have to have experts observe the person, interview the person, look into what the person did, and then come to their own opinion. In addition, the insanity defense is also problematic because juries are often confronted with opposing opinions about the defendant by different experts. Expert witnesses are people who are allowed to express opinions in court. This is different than ordinary witnesses. An ordinary witness is only allowed to testify in court about what that person saw, heard, felt, smelt, experienced. They can just relay what they saw like a tape recorder. They can't draw a conclusion from it. But an expert witness is a special witness. An expert witness is somebody who has a lot of knowledge in a particular field, and they're deemed an expert in that field. And that's based upon their education, their job, awards they received in their profession, publications on the subject. A judge looks at a person's background in a particular field and then will rule if that person's an expert or not. That's when that person is allowed to give an opinion, in this case, whether the person is insane or sane. Now, usually, you'll have the defense locating and putting on the stand expert witnesses that testify that their client is insane and should be found not guilty because of the insanity. Whereas the prosecution usually finds experts who testify that the defendant is sane and can be held responsible. And that's a problem because juries are then confronted with differing opinions and who do you believe? Add to that the problem of so-called hired gun experts. Some expert witnesses have the reputation that if the fee is high enough, they will tailor their conclusion, their opinion, to what the person paying them wants. So if you're a defense attorney and you want an expert to say your client's insane, you'll go to one of these people and you'll pay them a lot of money and they'll come back and say, yeah, this person's insane. And it can happen on the other side too. These are hired guns. Fortunately, such unethical experts are usually discovered after so many times and lose their credibility, but they still taint the process. Interestingly, the insanity defense is rarely used because almost everybody who commits crimes are sane. Even mentally ill people who commit most crimes are not so ill that they meet the higher standards of the insanity defense. Another reason why the insanity defense is rarely used is because even when a person is found not guilty due to insanity, they usually wind up incarcerated anyway. But instead of going to a prison as they would if they were found guilty of the crime, because they're not guilty by insanity, they go to a secured mental hospital instead of a prison. And that's no great bargain either. As a matter of fact, that's why if you're a defense attorney and you have a client who's clearly insane, but that client did not commit a very serious offense, committed a minor or medium offense where they would spend no time incarcerated or only a short period of time, you would never plead insanity, because if you pled insanity and you were successful, they could wind up in a mental hospital and never get out. Whereas if they went to jail or prison for a short term, they'd be released and free after that. So persons found not guilty due to insanity and who are also deemed to be a danger to themselves or others have to stay confined to a mental hospital until cured or no longer dangerous, which could be far longer than the term of incarceration they would have received upon conviction or plea bargain for a minor or moderately serious crime. So consequently, the insanity defense is usually only asserted by defendants accused of committing very serious crimes. Defendants who are facing life imprisonment or even execution. Those are the ones who go for the insanity defense. Throughout history, the insanity defense could mitigate, lessen, criminal responsibility, but not eliminate it entirely. But in 1843, an incident in England changed that and elevated insanity to a full criminal defense. In other words, it would totally eliminate all criminal responsibility and criminal punishment. The incident involved a mentally ill man named Macnaghten, who was delusional and tried to assassinate the Prime Minister of England, but wounded an undersecretary instead. He had a stellar defense team, and they argued insanity, and the court surprisingly found him not guilty by reason of insanity. This was new in England. Macnaghten died of old age in a mental hospital where he was sent instead of prison. But that decision resulted in the Macnaghten Rule. The Macnaghten Rule is also called the right-wrong test, and it's quite simple. It reads, to establish a defense on the ground of insanity, it must be clearly proved that at the time of committing the act, the party accused was laboring under such a defect of reason from disease of the mind as not to know the nature and quality of the act he was doing, or if he did, that he did not know that what he was doing was wrong. Thus, the Macnaghten Rule applied when the defendant was mentally ill and, as a result of the mental illness, either did not know what he or she were doing or the consequence of his or her acts, or if he or she did know what they were doing, that their acts were wrong. This was a revolutionary defense, and it became the law in England and the United States for a long time. But it was a law not without controversy, because there were problems in terms of defining what it meant to know right from wrong or what they were doing. Because this operates on two levels. There's the cognitive or intellectual awareness of what one is doing. But there's also a deeper psychiatric meaning, which also brings into play fuller, deeper knowledge, including emotions. So there's been a great deal of debate as to what the term know really means, and a lot of people were not comfortable with the Macnaghten Rule. The irresistible impulse test, or defense. As medical knowledge of insanity grew, it became necessary to modify the Macnaghten Rule to include impulsive and compulsive acts. The irresistible impulse test recognizes that the law should not only acquit a person not knowing an act was wrong, but should also acquit one who was unable to prevent themselves from committing the act despite knowledge of wrongfulness. In other words, psychiatry recognized that there could be people who knew what they were doing, even knew that it was wrong, and therefore they could not use the McNaughton test to get declared insane. But that these individuals, because of mental illness, might not be able to control their behaviors, to stop from doing the criminal act. The assumption is that there are mental diseases which impair free will, self-control, even while cognition, knowing what you're doing, remains unimpaired, and that these people can't use McNaughton, but nevertheless should be able to use the insanity defense. The irresistible impulse test was controversial, and some felt that it went too far in relieving criminal responsibility. Nevertheless, many states have adopted it. The Durham test. Following World War II, America became obsessed with science due to the invaluable role science played in winning the war. Scientific knowledge was increasing at an accelerated rate and was being applied to the fields of mental health and the law. Based upon new research, a new rule for determining the applicability of the insanity defense was devised by a federal judge. It was called the Durham test, and went further than most had ever imagined, and too far for many. The Durham test said, a person was not criminally responsible if the unlawful act was a product of mental disease or defect. Under the Durham test, a person would be relieved of criminal responsibility for a criminal act if he or she had a mental disease or defect, and that mental disease or defect was the reason for committing the unlawful act. People criticized the Durham test because they said it wasn't a test, it wasn't a rule. There were no clear definitions to guide the courts or even psychiatrists in analyzing people. Basically, they feared that anybody who was mentally ill and who committed a crime could find an expert to say it was the mental illness that was the reason for the crime, and they'd be relieving people of responsibility who shouldn't be found not guilty by reason of insanity. Even worse, it could easily be posited, based upon the Durham test, that drug addicts who are addicted, who possess drugs or sell drugs, that they were doing that because drug addiction is a mental disease, and they should be found not guilty of dealing or using drugs. The limits of the Durham test seem to be only limited by the imagination of expert witness and defense attorneys. It clearly had a lot of people worried. The Durham test went too far and potentially excused even drug addicts for drug-related crimes, and as a result, only New Hampshire uses it today, and even there, it's used in a modified form. The Model Penal Code's insanity rule. This is also referred to as the ALI rule because the group that promulgated it was the American Law Institute through their Model Penal Code, MPC. Everyone likes initials for brevity. So the American Law Institute's MPC rule is a combination of the McNaughton, irresistible impulse, and Durham rules. The Model Penal Code test is much broader than the McNaughton rule and the irresistible impulse test. Legal insanity requires the inability to understand right from wrong under the McNaughton rule, while the irresistible impulse test requires the inability to control an impulse. The MPC rule asks whether defendants are fully able to understand the criminality of their conduct or able to conform their conduct to the law, thus combining these two elements. It also requires that the mental disease or defect be diagnosed by a licensed medical health professional. In this way, it incorporates the main element required by the Durham rule. Now, there are some other little tweaks that take place in the MPC insanity rule. Instead of using the term knowing that is used in McNaughton, they talk about the defendant being aware. Instead of using the word control one's impulse, they talk about conforming to the law. And they also reduce the level of incapacity due to mental illness by suggesting that substantial incapacity would trigger the defense. Now, these nuances are important, but they're far too detailed and involved for an introductory penal code course such as this. But I wanted you to know that there was more to the ALI or the MPC insanity rule than just combining a little from McNaughton, a little from irresistible impulse, and a little from Durham. There was considerable tweaking. So the MPC test also excludes psychopaths from availing themselves of the defense. There was a great deal of concern that people who are sociopaths or psychopaths, and that's another area that we're not going to go into here, but these are highly unsocialized people who are quite rational and often calculating, who commit bad acts with virtually no guilt. It doesn't allow them to use the insanity defense. In the case of Arizona, we use a modified McNaughton rule where the burden of proof is on the defendant and a guilty but insane verdict is allowed. The diminished capacity defense. The diminished capacity defense concedes that the defendant committed the criminal act, but that some factors such as mental illness prevent the defendant from performing the criminal intent needed to be convicted of a serious crime. In other words, the diminished capacity defense suggests that the intentional mens rea wasn't there because of mental disease or defect. Now, the diminished capacity defense usually does not result in a not guilty verdict. Instead, the person may be convicted of a lesser crime not requiring intent, such as manslaughter instead of murder. The diminished capacity defense represents the struggles which society has had in differentiating between the mad and the bad criminal. In other words, a person who is sane and bad who kills deserves severe punishment. But somebody who is mad, not bad, mad because of mental illness and not bad who kills, shouldn't be punished and treated the same as the bad actor. Thus, the diminished capacity defense comes in. The diminished capacity defense resulted in the conviction of San Francisco County Supervisor Dan White for manslaughter instead of murder after he assassinated fellow Commissioner Harvey Milk and San Francisco Mayor George Moscone. Contrary to media reports, the cause of White's diminished capacity was depression and not eating junk food, such as Twinkies. The eating of junk food was offered as proof of his depression. Eating junk food was never asserted to be the reason he killed. The Twinkie defense is a misnomer. Guilty but mentally ill. Guilty but mentally ill is a plea that recognizes the mental illness of the defendant, but also acknowledges his or her guilt and blameworthiness. The defense may reduce the criminal liability and also provides for mental treatment in the prison the person is sent to. Arizona uses the guilty except insane defense as its insanity defense, but does not recognize irresistible impulse or diminished capacity. In addition, Arizona does not use the unawareness of the nature and quality of the act part of McNaughton. In other words, in Arizona, the only part of McNaughton that is used is unable to understand the wrongfulness of the behavior. Arizona's insanity defense is in Title 13, Section 502. A person may be found guilty except insane if at the time of the commission of the criminal act the person was afflicted with a mental disease or defect of such severity that the person did not know the criminal act was wrong. Note here, it doesn't include was unaware of the nature or quality of the act. Arizona statute goes on to say, a mental disease or defect constitutes legal insanity is an affirmative defense. Mental disease or defect does not include disorders that result from acute voluntary intoxication or withdrawal from alcohol or drugs, character defects, psychosexual disorders, or impulse control disorders. So right off the bat, they are excluding a large number of people who might otherwise try to use this guilty but insane defense. The statute goes on. Conditions that do not constitute legal insanity include but are not limited to momentary, temporary conditions arising from the pressure of the circumstances, moral decadence, depravity, or passion growing out of anger, jealousy, revenge. Again, more potential uses of this defense are excluded. It then goes on to state the defendant shall prove the defendant's legal insanity by clear and convincing evidence. This is a higher standard than many states have for insanity. Many states use preponderance of the evidence, which is 50% plus a little bit more goes your way. So once again, we see Arizona makes it much more difficult to use the so-called insanity defense. It requires clear and convincing evidence, more than a preponderance of evidence, although less than proof beyond a reasonable doubt. There have been challenges to the strictness and severity of Arizona's insanity defense. It went all the way to the U.S. Supreme Court, and they ruled that Arizona's limited defense is constitutional and legal. The infancy defense. The infancy defense asserts that the defendant was too young to form the mens rea for a crime. The infancy defense is an excuse defense. Remember, an excuse defense is one where the act performed is admittedly bad, but we're excusing the person who did it because of something about them or the situation. In the case of the infancy defense, it's something about them, their lack of age and maturity. Now, in the United States, children are said to be too young and immature to form a mens rea or a guilty mind. Now, under the common law, the age of criminal responsibility was 7 years. In other words, under common law, children under 7, no matter what they did, would not be charged with a crime. Under common law, between the ages of 7 and 14, they were presumed to not be able to be criminally responsible, but that presumption could be rebutted in court. Today in the United States, the age of criminal responsibility varies from state to state, and it ranges from 6 to 12 years of age. Children below that particular age cannot be charged with any crime. However, even after the age of criminal responsibility is reached, young people are often spared full criminal liability, and instead they're treated as juvenile offenders with less severe sentences and sentences geared more towards rehabilitating them than punishing them. Generally, children under the ages of 6 to 18, depending on the state, are considered to be juvenile delinquents, and their cases are handled in family court instead of criminal court, with an emphasis on treatment and rehabilitation with short sentences, if any incarceration time at all is involved. These children were also isolated from the criminal justice system. When I was a cop in New York, if we arrested a juvenile, we would not take them to the detention area. We would not take them to an area with other criminals. We would place them in a special room that was more like an office or a lounge, a room that had to be approved by the family courts for the holding of juvenile offenders until they could either be brought to juvenile hall or they could be picked up by their parents or guardians. The rehabilitative family court concept took hold in the early 1900s as part of a reform movement. when children only committed minor crimes, shoplifting and truancy. But in the 1960s, some children began committing very serious crimes and even violent crimes due to their involvement with drug crimes and gangs. In response to this change in the nature of juvenile crime, some states created the new category of juvenile offender and treated these more hardened juveniles almost as seriously as adults, and they did so in adult criminal court. Juvenile offenders could be as young as 13 if the crime was murder, arson, rape, and other horrendous acts. For less horrible but serious crimes, they were deemed juvenile offenders at the ages of 14 or 15, up to whatever the age of an adult offender was in that particular state. So in other words, in New York, where the age of adult responsibility was 16, a 13-year-old who committed murder 1, arson 1, rape 1, assault 1 at age 13 was a juvenile offender. If it was manslaughter or rape in the second degree or a lower degree of arson or aggravated assault, they might be a juvenile offender at 14. And for somewhat less serious bad crimes, the juvenile offender statute didn't kick in till 15. So the age at which juveniles become adults varies from state to state. It's as young as 16 in 7 states, including New York. Most states, 41, have the age of full criminal responsibility at 18. In Arizona, at 18, you're treated as an adult. Note, however, that some states classify adults between the age of adulthood and about 21 as youthful offenders, and they get less severe and more rehabilitation focused on